So the difficulty is that liberty will not be of much use in many cases because now the limitation has reduced from 4 years to 3 years. So most of the cases are falling under 4 years, so department is losing. So we wanted to file a detailed counter. Let the state continue. We have no objection.
So how soon are you going to file?
That's around 3.
Because the year ending is there and the assessment is being going for time hard. So any week.
So in that case, the delay in adjudication before us is not going to alter either of the.
No, madam. No.
We should not be blamed later.
No, not at all. Not at all. And madam, it may benefit the assessee. It will never benefit the department. But since department wants to bring all the position of law before my lord, so that is the view the higher officials have taken. So therefore, they have called for the SLP also, which has been filed in the Supreme Court.
Very well. It's a pan-India issue, so naturally the department has to be consistent in its stand, not a hurried stance. So item 21 to 25. Mr. Then council appearances, both Kalikhadi here. Mr. Rahul Lamba and Mr. Amrit Singh. Then counsel for the respondent income tax department pray for longer time to file counter affidavit as the legal issue involved has pan-India effect. Stop. 3 or 4 weeks.
4 weeks, madam.
They pray for further 4 weeks time to file counter affidavit. Stop.
They will file the agenda.
So, let the matter appear on 11th April 2022. 11th is open or closed?
11th.
11th April 2022.
I would say that very close. 18th or 19th April is because if at all required, they would be filing a agenda. So these are this time you would also be taking.
No, I thought that they would be filing by 5th or 6th April and 4 weeks would be completed by that period.
So we have to set aside if it comes on 18th or 19th, that would also be.
We have not.
Counter affidavit be filed latest by 11th April 2022. The matters be listed on 18th April 2022 as prayed for by learned counsel for the parties. In the meantime, interim order dated so and so shall continue till the next date.
Much obliged.
But there is one matter I have circulated a letter, serial number 14.
Yes.
I was praying this matter comes after the matter which is already taken up in the session of matters. That drug season matter.
When is that posted?
14 next week. 14 next week.
The counsel for the petitioner has prayed for an adjournment for which an email has also been circulated yesterday. Prayed for an adjournment with consent of the other side. Now, as prayed for, list the case after, in the week of 21st March 2022. ये ऑन हो गया कि ऑफ हुआ है? रेड से ऑन हो, रेड होने से ऑन हो.
From the very closing, under the heading for order, item 1, PA number 33 of 2019, Mr. Rahul Ahmad of the appealing, Mr. Sumit Chulia of the here we come.
But the only thing is that we are seeking a liberty to file a review before the IPA, but the issue is with respect to section 2 we are seeking the liberty to move before the IPA in accordance with the process.
So, is there any written instruction which you want to bring on record, or on your instructions we can?
My submission that you have.
Then counsel for the appellant income tax department, Mr. Rahul Lamba, seeks permission to withdraw this appeal on instructions. However, with the liberty to prefer a review application before the ITA. The appellant counsel for the respondent, Ms. Akanksha Mehta, does not object to the prayer. Accordingly, liberty is allowed. The instant appeal is dismissed as withdrawn. It is up to the petition appellant to seek review of the impugned order if permissible in law before the ITA. IA number so and so stands closed.
Item 2, appeal number 177 of 2019, Mr. Bhargav Prabhu for the appeal.
This matter was last posted on 7th on 28th February, madam.
Yes.
Now that correction has not come on the government that day. In this case, the opposite party, I filed for nullity, madam. The opposite party has not appeared before the lower court, madam, and I still was dismissed from the one case. Thereafter, I filed the appeal, madam. Here also a number of times attempts were made to serve notice to the opposite party, but they are not. They are not compromised. On 24th, they have never allowed my time for filing for the notice to issue the application. And filed supplementary application.
Supplementary and record.
The nature of the application was done by the proceeding.
So this affidavit is for service of notice through paper publication.
As per the order, all 24/11. The time of notice at 2 places, ma'am, that the last known address as well as the local address. Common address, ma'am. It has been done at both the places.
Reference may be made to the order dated 24th November 2021. Stop. Interlocutory application number 4141 of 2021 has been filed in pursuance thereto for effecting service to paper publication in terms of Order 5 Rule 20 of the Civil Procedure Code. Stop. Then counsel for the appellant submits that both the addresses of the respondent, that is the last known address, both the last known address of the respondent and also the permanent address. Yeah, notice would be taken on both the last known address and the permanent address of the respondent, which are enclosed to the instant IA.
Supplementary filing and record filing.
So, supplementary affidavit you have filed.
Yes, ma'am. It has come on report on 26th. On 26th February 2022, it had come on report. When the matter was last discussed on 28th February, matter was directed to place that on report.
Your Instagram is last office movement to make.
सब जगह 2/22 का है भी उसके बाद
After the last order, there is no office note.
yes
which is indicated in the supplementary affidavit filed by the appellant on 26th February 2022. 26th February 2022. Stop. Steps be taken for service of notice through paper publication on the last known address of the respondent and also at the permanent address through two regional newspapers having wide circulation in the places where the respondent last resided and also her permanent address, one in Hindi and another in English. Stop. Official serve the draft of notice through paper publication upon learned counsel for the appellant within a period of by 15th of March 2022. On service of notice to the aforesaid mode, appellant shall file a supplementary affidavit enclosing
supplementary file किया हम लोग का रिकॉर्ड है ये स्टेलिंग की supplementary file
paper publication से serve कर दिया और उसका proof करना है. You mean to say that notice has been already effected and supplementary affidavit is a proof of that?
Yes, sir.
Pass on that supplementary affidavit. So you pass on your
entire file.
दोनों पर. तो फिर यहाँ लिखे थे रेफरेंस में भी मेड टू द ऑर्डर डेटेड उसके बाद लिखिए A supplementary affidavit has been filed by the petitioner on 26th February 2022 showing service of notice through paper publication on the last known address and the permanent address of the respondent. Copy of the extract of the newspapers are annexed as Annexure 3 series and Annexure 4 series. Stop. Respondent has not entered appearance. Respondent has not yet entered appearance. Stop. Service of notice is treated as valid. Stop. Admit. Call for the lower court records in connection with so and so from the court of Science.
WPT number 177 of 2021, along with item number 4 and 5, Mr. Nitin Kumar Kothari, for the petitioner, Mr. Kumar Yadav.
In these matters, our preparations are not yet full. We'll keep it on next Monday. So we have to pronounce the order. Virtual day, then it would be after Holi only. And who knows, all the days would become physical in the meantime. Let us see next Monday because we do not want to delay on our part. post the cases on 14th of March 2022. Appearances recorded.
Admission item 6, LP number 303 of 2018. Mr. Pandey needed as for the friend.
This is from a judgment arising from my order. Not
17/9/19 का ऑर्डर है।
लवली कुमारी, हाँ, ये तो सर मेरा केस। This matter has wrongly been listed before this bench. In view of the order dated 17 September 2019. Stop. Let it be placed before the appropriate bench. ठीक है, ये ऊपर में क्यों नहीं लिखा? उसमें भी नहीं है ये। आइटम 11 में भी नहीं लिखा हुआ है। मेरा एनपीए सेक्शन के इसको बनाइए। ऊपर में लिख देने से फिर मेरे पास नहीं। और वो 11 में तो मेरे उसमें भी नहीं लिखा।
ये वाला पता नहीं किस कारण से। उसको तो आप कैसे लिखा? Not to be pressed or informed.
Item 7, CMP number 533 of 2018. Mr. Srikapta Sinha for the field.
नोटिस नहीं गया तो अभी भी किया जा सकता है। रिक्विजिट्स ने फाइल किया। नोटिस इशू हुआ, रिक्विजिट्स नहीं हुआ।
नोटिस इशू
रेस्पोंडेंट अपीयर नहीं किया इसमें। नॉट फाइंड
नोटिस कर देते हैं।
वेरी इन्फॉर्म नोटिस इशू हो गया तो अपीयर नहीं वही
issue notice on the respondent opposite party under registered cover with AD and speed post for which requisites we filed with 1 week. This thin petition also you want to? Only CMP. 1 week peremptory.
Item LP number 34 of 2019. Mr. Vijay Shankar Prasad for the field. Mr. Ravi Kumar for the response.
Hello. Against the order.
This was my
Who is for the state? What is the proof of the performance of work during that period of limitation? Not only that certificate of forester, not only the certificate of forester. Seven. Is
It is the advocate position that the forest
plus,
department.
if you have placed an extra 7,
Annexure 7.
Yes.
Annexure 7, grade 27.
so this is an order passed after being remitted in the previous round. After the matter was remitted, इसको बंद करवाइए जरा. उधर से नजर नहीं आ रहा है because of the glass. Window का light जो आ रहा है. After the matter was remitted by this court in the first writ petition, Annexure 7 order was passed. We are asking that besides the certificate of a forester of 2014 in 4-5 lines, is there any other proof that you have performed duty as a daily wager during that period?
I can tell the name. Annexure 7 is the order passed by the conservator of forest. Now, after the directions made by this order, it appears from this annexure that the business was appointed. I can tell the lordship that the business was appointed at the daily basis employee. And why? One thing, lordship, annexure sold, or 1 and 2 of the annexure sold, that he has been appointed at the annexure 7, or 1 and 2, admitted position is that the business has been appointed at the daily wages employee. Now the question is that for how long is sustained as a daily wages employee? I will be committed to 1 and 2 of these annexure. Passed by the मुख्य वन संरक्षक क्षेत्र निदेशक पुरानो प्लान परियोजना डाली और श्री राहुल कुमार पिता को वन क्षेत्र पदाधिकारी महुआ का वन क्षेत्र के पद संख्या 235 दिनांक 19/9/2011 द्वारा तत्कालीन वनपाल श्री अजीत नारायण सिंह द्वारा वन क्षेत्र पदाधिकारी महुआ डाल के वास्ते हस्ताक्षर का वनों एवं वन प्राणियों की सुरक्षा इत्यादि हेतु दिनांक 19/9/21 के पूर्वाह्न से प्रतिनिधित्व किया गया है. Now, one thing is clear: he has been appointed. He has been appointed. Now, also, we are to पुनः श्री अजीत नारायण सिंह तत्कालीन वनपाल महुआ डाल द्वारा वन क्षेत्र पदाधिकारी महुआ डाल के पद संख्या 256 दिनांक 26/9/11 द्वारा श्री राहुल कुमार गुप्ता को विभागीय कार्य के संपादन से मुक्त करने का निर्देश दिया गया है. Now, after appointment, on 26, they terminated the Rahul Kumar. I can present the appointment of Rahul Kumar.
Difference is 5 months.
19/9/11 अभी 26/9/11 यहाँ पे तो ये प्रूफ हो रहा है 19/11 26/11 में इसको भी जोड़ दिया तो इसके बाद कहाँ कागज दिखा कागज के पास
Yes, what?
My first point is the appointment as a daily wages employee of Rahul Kumar in the forest department for working in the area of Bangladesh has not been disputed. Admitted position given from the annexes. Now also annexure 1, 2 and 3. All are the letters and the certificates provided by the authority of the. It goes to show
that the round work as a delivery employee from 19 to 25 को 15 regular
without any wages.
without
Any muster roll?
master look at the result.
Any proof that his attendance
So the access
certificate
election key running petrol given.
certificate by a forester? No muster roll, no attendance.
तो डेली वेजेस पूरा लेता है वो काम करवाता है उसके बाद
4 साल तक बिना डेली वेजेस के आप काम भी कैसे कर सकते हैं? You work 8 hours at least, in fact more than 8 hours normally. And how can you survive?
I'm on value myself, and so far the remuneration is concerned also.
The remuneration is only if there is a proof that you have worked.
The remuneration is at this.
Otherwise, it is only a blank piece of, it's a piece of paper without any proof that you have worked.
Also, the election 1 and 2, all are granted kind of.
Questions of fact. If the read court has taken a view, why should we say that it is an incorrect view? We don't have anything more than what the read court has appreciated, and we do not find any error in the appreciation on facts.
I also make a point to the report regarding the conditions made in excess. Now, also, I have one finding to say. My intent prayer is for the letters provided by the chief conservator of forest. That will be discussed further. The now question is that only that for what period from the date appointment is not disputed.
There is no appointment for a daily wager, Mr. You know very well.
Except the certificate.
Every time you are using the word appointment, had there been an appointment, he would not have been a daily wager. Daily wagers are engaged,
Engagement.
and no letter is also issued.
Letter.
Only the muster roll.
So, regarding the remuneration.
समझ गए भाई?
Submission is asked.
I have understood, we have understood. 3-4 times you have repeated that thing. We are only patiently giving you opportunity to exhaust your argument. Otherwise, we have understood that beyond that there is nothing on.
Except certificate.
Cannot be the.
Very well.
So, I think any directions regarding the regulations.
You already had a direction from the first.
Regarding the regulations, in the much as we have the regulations, at this point of time after the order and the challenge that not getting any directions. So my normal prayer is only that only directions regarding the regulations.
Third learned counsel for the appellant, Mr. Vijay Shankar Prasad. Stop. Petitioner's claim. Petitioner is the appellant, being aggrieved by dismissal of the writ petition service number 2666 of 2015 by impugned judgment dated 11 December 2010. Stop. Under challenge was the office order number 21 dated 29th May 2015 passed by the Chief Conservator of Forest cum Field Director Palamu, whereunder the claim of petitioner for disbursement of arrears of remuneration was rejected. Stop. Such order was passed, Annexure 7 was passed by the Field Director Palamu upon direction of the learned writ court in the previous writ petition WPS number 5593 of 2013 by order dated 24th March 2015. Stop. Admittedly, beyond Annexure 3, which is a certificate of the forester Mahua of 26 February 2015 to the effect that between 19 September 2011 to 25 February 2015, petitioner was working in temporary capacity in Mahua range office. Range. There is no other document such as muster roll or any attendance sheet which could show that petitioner indeed worked during that period. Stop. Learned writ court took into account the petitioner claim of the petitioner that he was under deputation from 19 September 2011 till 26 September 2011 as evident from Annexure 7 under Range Officer Mahua. But in the absence of any proof of actual performance of work as a daily wager during that period, it refused to interfere in the order of rejection dated 29th May 2015. Learned counsel for the petitioner has reiterated the facts placed and drawn the attention of this court to Annexure 3 and Annexure 7 and submitted that petitioner's remuneration still remains due. We find it difficult to accept the contention of the petitioner. We find it difficult to accept this contention in the absence of any proof or documentary proof of actual performance of duty during this period as a daily wager. Stop. It would also be difficult to accept that for 4 long years petitioner worked as a daily wager without any remuneration. Stop. The issue raised by the petitioner appellant hinges on disputed questions of fact on which the learned single judge has taken a view which cannot be said to be erroneous, calling for our interference in the appeal or substitute view of the matter by taking a substitute view of the matter. The appeal being devoid of merit is therefore dismissed.
Item 9. PA number 34 of 2019. Ms. Amrita Sinha for the applicant. Mr. Mahin Kumar Chaudhary for the
This is some task within a short time, instruction on the market. Although I have not received any specific instruction.
Your instruction itself says that you have to withdraw.
But yes, Your Honor, but I have received internal communication where the PCIT has given the consent to withdraw. That's sufficient.
The instruction में ही लिखा हुआ है.
The internal communication through mail which I have received.
So you forward it through mail. You forward this through mail.
Okay, I will forward it to you. I have just taken on the print out also.
Okay. Then counsel for the appellant, Income Tax Department, Ms. Amrita Sinha, seeks permission to withdraw this appeal in view of the instruction contained in the internal communication dated 25th February 2022. As the tax effect in the case is rupees 2,13,880.
No, Your Worship, 78. This is not related. Tax effect.
Acha, 78,000, 78,63,030,
Including penalty,
including penalty.
interest and penalty.
Interest and penalty. So, the internal communication has been, the internal communication containing the notings of the Principal CIT Dhanbad dated 25th February 2022 be kept on record. Appellant counsel for the respondent does not object to the prayer. Accordingly, the instant appeal is dismissed as withdrawn. So the lower half of that, separate.
इधर करते हैं, तो instruction में ही लिखा है. तो सब एक लाइन से इंस्ट्रक्शन नहीं है स्पेसिफिक.
Same order in item 10. Respondent is not appearing. अभी notice नहीं हुआ है. Tax effect 90. Including.
Only the issue is only with respect to.
Issue is only 230.
As the issue involved is only in relation to the levy of interest under section 234 capital B of rupees 3,12,863 only. This interest is on the assessed income.
Yes, Your Worship. It have to be, the interest has to be levied on the assessed income, but there is a when it said that it is to be levied on the return.
But the amendment came in
And
2000.
the explanation what was it?
Accordingly, the instant appeal is dismissed as withdrawn. Let the instruction be kept on record. Same 25th February 2022, the Principal CIT, Dhanbad.
item number 56 of 2019. Mr. Sarasekar for the appellant. Mr. Amit Kumar Das for the
Wrong mistakes.
Let the matter be placed before a bench of which one of us. इसमें सुजीत बाबू का भी है। अच्छा वो उनका तो इसके क्लियरेंस के चलते
हाँ उसके अपीयरेंस उसके बाद आपका दोनों का हाँ इंक्लूड जजमेंट
with the matter will place before a bench of which one of us, Krish Kumar Singh, within bracket, is not a member. ठीक.
QB number 98 of 2009, Mr. Anand Kumar Sinha or
This was at the stage of removal of defect. The judgment has become final. No reasons are there. Notice. Issue notice on the opposite party under register covered with a D and speed post for which requisites be filed within 1 week per entry. Obviously, so long this is not restored, first appeal is not on record. 1 week per entry. 1 week per entry. Speed post and registered cover. ये आइटम 15, 16, 17, 19, 20 ये सब जरा सॉल्व कर लीजिए.
Item 15, CA number 2 of 2021, Mr. Raulama on the appeal line.
Mr. Lamba, instructions are required before issuing notice or?
Well, in fact, this matter is a matter where the department is saying that this falls under exception. What had happened under the tribunal? The matter was there. The tribunal took a view that this falls under the prescribed monetary limit. And because there was a penalty issue, and the tribunal said that exceptions which are available will not be applicable because exceptions are only for tax effect and not for.
No, there is old circular of this monetary limit penalty, amount of penalty will be treated as tax effect. Yes.
That is what the stand of the department is. If the monetary limit is applicable to both, then the exceptions are also applicable.
You file affidavit in that case.
But the tribunal has taken a view that exceptions are not applicable to them. That is the question.
Because all the notification is to be read conjointly. That is the last line in every notification.
Actually, my lord is absolutely right. In all the notifications, it is written that tax and penalty will be considered as same.
What is the penalty? What is the penalty amount in this case?
So the penalty amount is very less.
Then how you can challenge here?
That is what the department is saying that it is falling under exception.
How?
That was the case, Madam. If Madam can have the tribunal order.
No, I am just looking to the assessment order. The total penalty, 300% penalty, etc., all inclusive, 1,88,000. So this is the disputed amount, including penalty. So if we take tax also as penalty, I mean penalty amount is also as tax, then how?
It is an exception. The limit is below the monetary limit. The effect
Yes.
is below the monetary limit. But it is falling under exception. That is what the case of the department before the tribunal was. Now, can have page 24.
Have you explained that thing in your memo of appeal at any place?
That is also explained in the issue order itself.
So that we understand.
24 months. At page 24, in color page 2 of the order.
Yes.
24 paragraph, the mandatory permission.
Read para 3 also.
We find that the intention behind the circular number 17 of the 20,000 is understood in the following perspective. Further, with a view to provide clarity in filing of appeals in scenarios where sacred orders passed by higher appellate authority for each assessment year, vis-à-vis where composite order for more than one assessment year is passed, para 5 of the circular is substituted by the following manner. Para 5. Assessing officer shall calculate the tax effect separately for each assessment year in respect of the disputed issues in the case of every assessee. In the case of an assessee, the disputed issues arise in more than one assessment year. Appeal can be filed in respect of such assessment year or years in which the tax effect in respect of the disputed issue exceeds the monetary limit in priority. No appeal shall be filed with respect of an assessment year or years in which the tax effect is less than the monetary limit specified in priority. Further, even in the case of composite order of any high court or appellate authority which involves more than one assessment year and common issues in more than one assessment year, no appeal shall be filed with respect of an assessment year or years in which the tax effect is less than the monetary limit specified in priority. In case where a composite order judgment involves more than one assessee, each assessee shall be dealt with separately. But this issue was not there. I don't know why I just quoted this issue. On perusal of the circular number 17 of 2019 dated so have the materials available on the form. We do not see this case falling under any of the exceptions contemplated in the said circular per se. We also find that this circular makes it very clear that the revised monetary limits shall apply retrospectively to spending of the well. Honorable Episcopal Commission of Customs was the Indian Oil Corporation
वो सर्कुलर सबका एक दिया था ना लंबा.
Mr. Mohanty has vehemently argued that the instant issue of bogus long-term capital gains falls as an exception to the above stated CBDT circular. He appears to dispute that the foregoing exception applies to quantum only and not to revenue. But the submission of the revenue must that the exceptions are common. There are no separate exceptions which are for the quantum.
सर्कुलर्स का एक दो सेट दिए है ना, एक हमारे लिए, एक इनके लिए, एक आपके पास रखने के लिए एग्जेम्पशन का सेट.
I have it on my email address. I can resend it.
How many copies had you given?
But I have given in a soft copy. I emailed the
Okay,
circular.
okay.
मेरे ख्याल से इनको इस इशू पे तो कन्विंस नहीं है तो एफिडेविट सेपरेट करें. You should file an affidavit.
Submission of the department is that it is falling under exception. To which the tribunal is saying that those exceptions are for the tax.
So you mean to say the exception number 2 of paragraph 9 of the notification that any order which is in contravention to some rules, circular, etc., you want to bring this case in that forum. That can be one of these.
That is the. I first have to satisfy my lord that the exceptions are applicable to both. tax effect as well as.
Yes, that is okay.
That is the first thing.
Okay.
Then I get out of the tribunal's order which say that you cannot apply those exceptions to penalty proceeding. Then my lord, my next duty would be to demonstrate to my lord that out of the 7 exceptions, which is the exception applicable in this case.
Should decide whether the penalty amount कभी और circular में होगा 2015 का ही दिया है आईचे को चंबा में है restriction.
You have an extra copy of that circular.
In 2015-16 there was a specific here about penalty amount shall be treated as tax amount.
In the 2018,
Okay.
Just pass it for our consumption, we'll give it back to you. Meanwhile, you resend it so that they can take out a print out and keep it here.
Eighteen में दिया हुआ है.
15 वाला कौन सा है? ये. ये वाला है, इसको लोग साइड कर रहे हैं. Exception तो इसमें नहीं है.
एक्सेप्शन पहले वाला इसी में लिखा होगा. T of 18 में हो गया. पेनल्टी का काम in 2018 where is reference of penalty?
Circular 3 of 18 not the new guidelines. It superseded all the guidelines. It was a comprehensive circular, which laid down the monetary limit and which laid down in paragraph 10 the exceptions. Now, this was amended subsequently. Initially, there were 4 exceptions. Then, subsequently, by way of a circular in August 18, the exceptions were enhanced by 2 more exceptions. So, total 6 exceptions were there. Subsequently, in 2019, there was another circular which added 1 more exception. Now, the total exceptions are 7, and the monetary limit which was in circular 3 of 18 lakhs 50 lakhs was further enhanced to
1 crore.
in end of 2019. So, this is the entire background. Now, the paragraph 10 of circular 3 of 18 can be seen. It lays down the exception.
3 of 18, yes. Which exception you want to say? Paragraph 10.
First, I have to show that the penalty, these exceptions are also applicable for penalty. Because that is what the tribunal has said. Tribunal has not rejected my appeal on the ground that no exception is there. It says that these exceptions are not available to penalty.
Yes, yes, I understand. Where is that? Because I have read that.
I am just looking for the part in the circular to say that penalty and tax effect are same.
Are same. Was where it is? I want. Have to.
There are 4 methods which define what tax effect is. Circular 3 of 18 find what tax effect is. And the last 2 lines, in case of penalty, what
Yes. Yes.
it has a, would say, it's the exception law with respect to tax return. So what the tribunal has done, it might not, this might not, para 4 might not have been brought before the tribunal. So tribunal also the view that exceptions are not available for penalty provision.
In the present case, it's a question of penalty. Relying upon circular number 3 of 2018, in particular para 4, Learned Counsel for the Department, Income Tax Department, Mr. Rahul Lamba submits that the impugned order of the learned ITAT has taken an incorrect view that the CBDT circular laying down the monetary limits and describing the exemptions under which an appeal can still be preferred applies only to quantum and not to penalty proceedings. Stop. Issue notice on the respondent in the registered cover with the deed and speed post, for which requisites be filed within 1 week. Rem. Additionally, notice be effected on the official email address of the respondent containing the attachment of memo of appeal and its annexures within the same time, and an affidavit to that effect be filed within 1 week thereafter. Office to track speed post delivery. ये इनका सब वापस कर दीजिए और हम लोग कभी निकालें उसको यहाँ 2 सेट ये भी करना and that is there. Other cases 16, 17. I said.
Year number 5 of 2021 is available.
Amount is very less.
Stating that it does not fall below the monetary limit. Again, the issue is that it falls with the exception clause, that is the exception clause added on 23rd circular number 23 of 2019, wherein it has been held that the organized tax evasion activities falls under the Tax Evasion Act, and these are the
For foreign investment, perhaps.
the circular number 23 of 2019.
Yes, circular.
This is September 6 of 2019. Circular number 23 of 2019, the letter circular.
Yes.
Yes. The subject exception to monetary limit for filing appeal specified in any circular issued under section 22. Para 3 is important. In this context, board has decided that notwithstanding anything containing any circular issued under section 268A, specified monetary limit for filing the departmental appeals before the Income Tax Appellate Tribunal, High Court, and SLP's appeals before the Supreme Court. Appeals may be filed on merit as an exception to said circular, where both by way of special order direct filing of appeal on merit in cases involved in organized tax evasion activity. So here it is like all the companies from which they are taken are based on total and they are continuously every year they are involved in such kind of activities and the addition is done under section 68.
Any share issue? Any share?
Yes, sir. Very soon. And para 4 also in the para 1 also has stated that it falls within the exception clause of the CBDT circular. Then in para 4 also has stated and in the ground of question.
ITAT has simply gone by the circular.
Simply gone by stating that the amount falls below the monetary limit. They are not examining the circular. Even the latest circular that was there in the year 6th of September 2019, that was also not examined by the ITAT.
So you have to convince whether it is an organized tax evasion or not.
Yes. And that circular was there at the time when ITAT passed the order, and the order was passed on 22nd of July 2020. However, the circular came on 6th of September 2020.
Issue notice on the registered cover with heavy and speed post on the respondent. On the registered respondent, for which requisites be filed within 1 week. Additionally, notice be effected on the official email. Appellant shall also effect notice on the official email address of the respondent containing the attachment of the entire memo of appeal and its annexures within the same period and file an affidavit to that effect within 1 week thereafter. Briefly.
If the affidavit is required to file in this paper, then all the notices and requisites will be filed within 1 week. The supplementary can be filed the next
Supplementary within 2 weeks.
Item 17, email number 6 of 2021, and submitted.
Also, same issue will not there at your mention.
Organized tax evasion.
Yes, sir.
And the ITAT has only gone by
Only by the
circular.
the amount.
Hmm.
And read the ITC order.
Same order in the all three cases. Issue notice, same order.
Item 19, email number 11 of 2021, Mr. Ram.
I'll take instructions with respect to tax return. Give me a 2 weeks.
Mr. Devesh Poddar appears for the respondent. Wakalatnama filed
I'll be filing it by tomorrow.
and undertakes to file Wakalatnama by tomorrow. On filing of Wakalatnama, let his name be reflected in the cause list. Thereafter, stop. Counsel for the appellant, Mr. Rahul Lamba, seeks 2 weeks' time to obtain instruction as to the tax effect of the disputed amount and whether it falls within the any of the exemptions provided under the CBDT circular.
एक्सेप्शन में लिबरेट कर दिया ना कैसे
Item 20, email number 12 of 2020, Mr. Amrita Singh, author.
issue involves interest in the section 234, it falls within the monetary limit.
This will go.
And counsel for the appellant. Any written instruction? Any written instruction?
So in this case, I have not.
Okay. And counsel for the
The amount is for the same legal amount around 40,000.
instruction
You file affidavit and you go through the exceptions also again. You file an affidavit in this behalf, whether it will come under exception or not. You go through the exceptions again and rethink the exceptions and reanalyze each and every word of exception, and then you file affidavit whether you will withdraw or you will bring that thing within the four corners of either of the exception.
उसकी वैलिडिटी का क्वेश्चन में इन्वॉल्व नहीं भी रहा
यहाँ पे अपने यहाँ पे तो
रिटर्न इनकम सिस्टम का
यहाँ पे कोई practically it is not operating. Though it is a circular operating in the entire world, but in Jharkhand it is not operating.
फिर उसमें ये कर सकते हैं कि इस केस में उसका टैक्स इफेक्ट इंटरेस्ट रिटर्न इनकम पे भी 1 करोड़ से लेस है तो असिस्ट इनकम पे भी तो
फिर उसमें आ जाएगा
उसमें
नहीं वहाँ है तो हम आपको बोले तो
The highlighted portion from there. Yeah.
further tax effects
Further tax effect shall be taxed including applicable surcharges and cess. However, the tax will not include any interest thereon except where chargeability of interest itself is a dispute. And further it says that in case the chargeability of interest is the issue under dispute, the amount of interest shall be the tax. So the amount of interest shall be the tax effect, and when the only interest is under the issue. So
the issue of tax is lying pending since last 5-6 years. Your board itself would have clarified that
interest
that will be part and parcel of exception anyway.
you take instruction and bring it on affidavit 2 weeks time as per for is allowed to the counsel for the appellant to seek instruction as to the tax effect of the disputed amount and whether it falls within any of the exceptions of the CBDT circular listed after 2 weeks.
After purchase item meeting, first appeal number 10 of 2021, Mr. Pawar Chandra Jha for the appellant. Mr. Anuj Kumar Sinha, Mr. Kumar for the
Mediation has failed. Mediation has failed as per the report of learned mediator Jhalsa bearing letter number 502 dated 15 February 2022. Then counsel for the parties also submit that mediation has failed. Stop. Admit call for the lower court records in connection with so and so from the court of so and so. Parties are fighting for restitution. You want restitution, C is not agreeable. Criminal case pending. So you don't want divorce. Because if she is not willing to come, she might be willing to give divorce.
Then we have got no option.
But here also, one case, kind of, that was fine. That was dismissed from non-prosecution.
Place the matter under the heading for hearing on receipt of the LCR as per its age.
Item 13, LG number 412 of 2020. This is legal solicitor for the claim. It is out of
We all send us the text. And we all send, let us say, I was a tiny partner. उसके साथ अगर चेक कर दिया जाता है तो दूसरा
सुना तो नहीं लिखा हुआ है। नोटबुक पर वाला जो लिखता है, उसमें तो नहीं लिखा हुआ। मेरे गाँव से डिवीजन से आया है मेरे पास। नहीं कह रहा है। इसमें तो कोई मुश्किल नहीं है। Other cases have also been assigned to this bench. बाकी 4 अपील को भी इस बेंच के असाइन कर दिया गया है। आप इसको आर्ग्यू करिए फिर। We do not know whether they will be assigned or not. You are for Jack, and argue it. The only question is that you are not granting approval to the appointment of the petitioner as an assistant teacher in Madrasa because of your letter under which the appointment process should have been completed within 45 days. So,
And maximum time you have consumed in giving confirmation. Senior boss,
senior should have been ready. It has been listed after such a long time. 2020, this LPA has been recused in June 2021. It is of 2020. Who will appear? Pure legal issue. Purely legal issue. On facts, whether there was a delay from the date of advertisement till the date of the appointment on the part of the madrasa. No, they say, आप तब तक अपने सीनियर को बुलाने के लिए खबर करिए. Advertisement is of 1st January 2016. ठीक है? और appointment letter was issued on 15th February 2016. So within 45 days. Then? कब भेजा गया?
28/7/16.
What is the language of that letter? Language of the letter, विज्ञापन प्रकाशन होने की तिथि से 45 दिन के अंदर नियुक्ति की सभी प्रक्रियाएं पूरी होनी चाहिए. उसके बाद अन्यथा नहीं लिखा हुआ है. The sentence is not with a rider that in case it is not done, no approval will be granted. Jack has to give the approval. State government also has some role. अच्छा, part of the DO. हाँ, so the page number
बैठक में लिए निर्णय के प्रस्ताव 28/7/2016 28/7/2016 11:30 बजे मदरसा अध्यक्ष की मदरसा या के प्रांगण में एक आम बैठक मीटिंग आउट की गई जिसमें प्रस्ताव पारित सर्वसम्मति से यह निर्णय लिया गया कि 11/2/2016 को मौजूदगी पर इंटरव्यू में प्रथम आए मोहम्मद अब्बास अंसारी का स्वयं इंडिया टिकटॉक 11/2016 में जो इंटरव्यू हुआ था उसमें पढ़ता हूँ ये तो प्रोसेस अपने आप एडमिट करना पड़ती है साथ में इससे कितना कोर्स खैर मदरसा नियमित रूप से कर रहे हैं इसलिए इन दोनों की शिक्षा अनुमोदन हेतु सचिव झारखंड मंत्री परिषद झारखंड को भेजा जाए इसके नीचे उनको देखा जाएगा सब गुजरात में सेक्रेटरी का साइन है फिर प्रधानमंत्री का साइन है फिर जैसे विधायक प्रतिनिधि का साइन है इसका एडमिट है
रेडियो में
स्पष्टीकरण है उसमें भी ये बोलते हैं कि आपस में विवाद हो गया जिसके वजह से
आपने कोई फैक्ट फाइंडिंग इंक्वायरी किया है कि इनका ये रिक्रूटमेंट प्रोसेस 5 जनवरी से जो शुरू हुआ और अपॉइंटमेंट लेटर में किसी भी नियुक्ति प्रक्रिया में कोई कमी पाई गई कि सिंपली 45 दिन के बाद आपके पास भेजा गया अप्रूवल के लिए उसी के आधार पर आप इसको
आपस में विवाद हो गया था दो कैंडिडेट जिसके चलते इसको
वो तो आप एक लेटर से पढ़ रहे हैं ना आपने क्या किया हाँ तो
My lad wants to know कि apart from is there any statutory provision 45 दिन का कि simply आपका डिसीजन है एक्ट लेटर में
कोई गाइडलाइन है मदरसा
क्लेम का बेसिस होना चाहिए सर्कुलर और इंटरनल ऑर्डर खाली 45 यही बेचारे कहते हैं
थर्सडे को आइए फिर तैयार होके ऐसे केस जब टेकअप होने के लिए लिस्ट में आ गया है ना तो यू शुड नॉट प्रिज्यूम कि एडजर्नमेंट हो जाएगा यू हैव नॉट इन्फॉर्म द कोर्ट ऑल्सो मेनी अदर काउंसिल्स हैव प्रेड फॉर एन एडजर्नमेंट फॉर सम वैलिड रीजन मैटर इज ओल्ड you are working you are for the state oh, so private respondent has not yet been noticed you first convince us
What is the factual instruction क्या काम कर रहा है उसको मिला ही नहीं
ये तो
कंटेंट
मदरसे की तरफ से है मुझे इसलिए
इनको पता नहीं
both of you are from the state you don't know about ऐसे ही काम करना होगा अप्रूवल मिलेगा तो पैसा मिलेगा
पैसा मिला यही बोलते लेकिन यहाँ 10 साल बोलते हैं समझ नहीं आता
request of learned counsel for the appellant, Mr. Radhakrishnan Gupta, who was the case on Thursday, 10th March 2022. Approval process of recruitment is over. It's only a question of giving approval. Approval can be denied if the recruitment process suffers from some irregularity, illegality, or fraud, etc. Generally speaking, like it happens in the case of minority schools where the proposition statement can be approved by the Directorate of Secondary Education or Primary Education only if 3-4 criteria are met. Here, you are not alleging that the recruitment process is suffering from irregularity in the selection. Selection has been done within time. It is only the delay in sending for approval which is the basis, made the basis for refusing to approve. तो ये आपके clause 3 में there is no rider if it is not done within 45 days. And the question is again that if the recruitment has been done in 45 days, it is the madrasa which has made the delay, caused the delay in sending for approval. It's a purely a very hyper technical kind of a that too, not backed by any prescription of law. Very well. एक किस है मैडम?
अच्छा हाँ ठीक है चलिए खाली तो रहते हैं
Yes.
On the bill for addition, item would contain rupees 742 of 2021, Mr. Bhakti Martina for the police service. New chief place for the last so far, they have a next order.
Don't argue simultaneously.
And there was the revised reason.
This is the supplementary chauffeurs.
Why not go
So what is the outcome?
Numbers, we are only liberate the penalty as a quality 15, 10, 20, 21. So that is, we are
2020.
yes, 20. And after that, the only ET and EVT has been plus here. And penalty has not been liberate from 16, 10, 2020 to 15, to 29 January 2021. The period for which the delay occurred on March.
Place our order so that we can recapitulate what is the.
What has not been included? Please don't use short forms. What has not been included? Penalty has not been included.
Penalty.
And what has been included?
ET not and ET.
What
excise duty and excise transport duty.
Okay.
Para 8 onwards, place the order. Yes, place the order from.
Yeah, consider the submission of current possible parties in light of material facts and circumstances brought from record taken note of the law. As observed in the obligated 10-3-2021, the respondents were directed to explain as to why decision on the question of unseating of this petition was kept pending till 29/1/2021. Even though petition had submitted in reply 26/9/2020 and the report of the chemical analysis partner has been received on 15/10/2020 itself. The narration of the events and sequence of dates thereafter born from the counter affidavit of the state dated 14/6/2021 indicates that after submission of the inquiry report by the sub-inspector of excise, Southern Circle 2 on 28 10/2020, the matter remained pending for obtaining legal opinion from the assistant public prosecutor and thereafter from the legal judge to whom the file was passed, as late as 12/1/2021. On 14/1/2021, the Deputy Commissioner on seeking the decision to impose enhanced security fees based on opinion of 280 people. Since the Commissioner of Excise lastly was required for imposing enhanced security fee, the file was placed before him through letter number 73 dated 18/1/2021. And only by 29/1/2021 such decision of imposing enhanced penalty of 1 lakh for the irregularities committed by the petitioner was communicated to him. Currently, the delay in decision making after submission of the petition for 126 and 2020 and receipt of the chemical analysis report, Patna, by item number 816 dated 15/10/2020 was on account of the movement of the file in the office of the respondents and not on account of license material on part of the petition. Whereas the license of the petitioner shop has been cancelled on 22/2/2021 on account of failure to deposit excise safety and excise control duties to the tune of 2,61,720 and currently for media of deposit of CCT and of excise duty to the tune of 1,04,92,375, totaling around 2,07,00,000 before 1,105 rupees. Krishna has been punished with a fine of rupees 1 lakh for irregularities from during the extraction period on the legal of 22/9/2020. The cancellation of this license in account of not deposit of EP and EGP for the delay in deposit of excise duty was the sequence of days not developed. It is apparent that after the receipt of the report of chemical analysis but now on 15/10/2020, till the enhanced security fees was imposed on petition 21 on 29/1/2021. The petitioner was not responsible for the delay and the file was moving from one office to another or one office to another in the office of the respondent. Therefore, the delay of deposit of excise duty and excise control duty cannot, together with the penalty for the period of completed, the petitioner cannot be made liable.
Read your reasoned order.
Because I will be permitted to read from the internal history of document. But first one I read the entire thing.
Internal phase 3.
Read.
Well, after our quotation from yes,
अधिकारी द्वारा बकाया राशि शामिल करने हेतु करने हुए अपनी अनिर्दिष्ट का नवीकरण करके हेतु अनुरोध किया है। मान्य न्यायालय द्वारा यह कहा गया कि विभाग वन मछली चार माह 3 दिन के लिए सरकारी राजस्व क्षति के लिए अतिरिक्त सरकारी मान्य न्यायालय के द्वारा निर्देश आदेश नहीं दिया गया कि अवधि तक उत्पाद कर एवं उत्पाद परिवहन कर प्राप्त करना है अथवा नहीं। जहाँ तक गरीबी का नवीकरण का मामला है तो न्यायालय द्वारा नवीकरण के सीमित मात्र निकटते से राशि जमा की गई। बकाया राशि जमा नहीं किया गया। जब उत्पाद कानून की बंदोबस्ती एवं संचालन न्यायाधीश द्वारा भारत के निकट की नवीकरण के निर्देश पर बजट है जो निगमती द्वारा अनुज्ञाकारी द्वारा अनुज्ञप्ति निर्गत की तिथि से माह दिसंबर तक अवधि के समय उत्पाद परिवहन कर 21% ड्यूटी जमा कर दिया गया हो। यदि उत्पाद परिवहन कर विलंब से जमा किया गया हो तो उत्पाद विलंब भी इनके द्वारा जमा कर दिया गया हो। निगमती जारी द्वारा माह दिसंबर तक के लिए निर्धारित योजना ड्यूटी के अनुरूप मदिरा का उत्पाद कर लिया गया हो। यदि निर्धारित योजना कर के अनुरूप मदिरा का उत्पाद नहीं किया गया है तो राज्य सरकार को हुई क्षति की समतुल्य राशि स्वरूप समय सरकार में जमा कर दी गई हो। सरकारी के विरुद्ध राजस्व क्षति व संचालन से संबंधित गंभीर अनियमितता दर्ज नहीं की गई हो। वकालत के विवरण पहले एवं गंभीर अनियमितता दर्ज होने की स्थिति में नियोक्ता द्वारा कार्यान्वयन नहीं किया जाना है। दुकान के सीलबंद करने के दौरान सभी जांच प्रक्रिया संपूर्ण करने के प्रकाराधीन एवं नियोक्ता द्वारा से दोष की शिकायत किया गया है। माननीय उच्च न्यायालय झारखंड रांची द्वारा पारित आदेश का कार्यालय के पत्र संख्या 23/2/2020 के द्वारा नियोक्ता झारखंड उच्च न्यायालय रांची से अंदर की मांग की गई थी। महाधिवक्ता द्वारा दिनांक 3/3/2022 को उत्तर दिया गया कि दिनांक 15/10/20 तक उत्पाद परिवहन कर एवं विलंब शुल्क की वसूली संवेदनशीलता बरती जाए एवं दिनांक 16/10/20 से दिनांक 29/1/21 तक उत्पाद परिवहन कर एवं विलंब शुल्क की वसूली सौम्य दृष्टि से रखी जाए। उत्पाद अधिनियम द्वारा 42 में अंकित है कि the holder of the license permit or pass shall not be entitled to any compensation or cancellation suspension under this section or the refund of any fee or deposit paid in respect to thereof। प्राप्त मार्गदर्शन के आलोक में उत्पाद कर एवं उत्पाद परिवहन कर जो उत्पाद राजस्व का एक भाग है, इसीलिए अंतर्गत इस अवधि का उत्पाद कर एवं उत्पाद परिवहन कर को किसी प्रकार की राहत नहीं दिया जा सकता। इसीलिए इस अवधि का विलंब शुल्क को छोड़कर शेष राशि वसूली किया जा सकता है। पुनः दिनांक 16/10/20 से दिनांक 28/1/21 तक की अवधि में विलंब शुल्क की राशि छोड़कर बकाया राशि की गणना की गई है जो निम्न प्रकार है।
Mr. Piyush, please just let us know one thing. Just let us know one thing. Under what circumstance this delay in whatever you have done, the delay is admitted, and therefore his role is totally out. The delay was entirely attributable to you, right? You have asked him to deposit this excise duty and excise transfer. How is he responsible for that?
So the delay part has been controlled.
Excise duty and this transport duty will be paid only when he sells it, and it is very clearly indicated in the impugned order itself. You are referring to this particular clause of the license, that is, the holder of a license permit shall not be entitled to any compensation. Is it a part of compensation? No. Or for any refund. Is he seeking any refund? No. He is neither seeking any refund nor he is seeking any compensation. If you do not permit him to operate the shop for your own lapses, then under such circumstances, under what provision of law would you have realized this excise duty and transport duty? This is the reason why this observation was made by this court in para 8. You see, therefore, delaying the deposit of excise duty, excise transport duty together with penalty for that period, the petitioner cannot be made liable alone. Who is the person liable for non-payment of excise duty?
A lot of held that a delay had occurred on our part because our accident had caused the delay. But what we have said is that we have not levied any penalty for delay of payment.
You are making a mockery of the judgment. You should have challenged it. Go and challenge it. You are making a mockery of the judgment. Very adamant officer. You see, even the Advocate General has given a very enough indicative what is to be done. Enough indication what is to be done. If on account of your lapses, the shop remains closed, who will suffer? This amount of duty is payable irrespective of sale. Yes, irrespective of sale. But if you don't permit him to sell for your lapses, who will pay for it? Lordship, the officer should come himself and explain.
And what is this calculation? At internal page 4, Vilam Shulka Bakaya. What is this about?
The second column is the part and the part EDI, it's excise transport duty, and the second is the late fine, the late fee.
So you say that you are not charging the delayed penalty. Then why? How does this?
Only the period 15, 10, 20, 20.
So what is the period for which this delayed penalty is being charged?
It is only till 15, 10, 20, 20. The date on which we had received a chemical analysis reports from Patna. After that, we have not done.
No. This is not correct. Lordship is rightly pointing it out. What is the period? And on what amount? Give the calculation also, break up. No, your officer should come and explain. With calculator, he should come.
This date we only till 15, 10, 20.
How do you know and how do we know? The officer doesn't indicate it. And what is the total amount? 1 crore 94,000. No, 1 crore 9 lakhs.
Earlier, the total amount was inclusive of late fee was 3 crores 30 lakhs 85,560. Now we have revised it to 2 crores 14 lakhs 23,000.
So that is what we are asking, that how this 1 crore 9 lakhs has come. It is not indicated. Why should we keep on repeating? You understand English, we understand English. You understand in one sentence, you can understand. No, that doesn't suffice. Na? A person will become bankrupt and broke. 1 crore 9 lakhs, simply because he is a liquor dealer, do you perceive that he has tens and tens of crores in his bank account to pay you without you disclosing as to how much is the computation and how is the computation?
And subject to what the petitioner would say and respondent would say, there was also a concept of proportionate reduction of license fee also, on account of omission on the part of the state for not doing the needful, isn't it? There is a concept that is contemplated in the act also. Yes.
Provisions, of course, might be there, which Learned Council might point out, and sister is also saying. But on purely equitable grounds, you are condoning the penalty for the delay because he is not responsible. By the same reason, he will not be responsible for paying the excise duty and the excise transport duty. Can't be. It's as simple as that. Suppose the decision was taken on 16th of October, and then he did not lift the excise or pay the excise duty, excise transport duty. He cannot be allowed to say. He would not have been allowed to say that no. Still, I won't be liable to pay that. The consequence of that delay is not upon him, but he is made liable to pay because of the very basis on which you have computed the delay. So suppose a tax is to be paid on a particular date, and if it is not paid by that date, it has to be with interest and penalty if there is an adjudication proceeding, or if the penalty is automatic by statute. Here, the demand was to be deposited maybe after 15th or 30th October. You did not take a decision. The shop was lying closed. He could not have lifted and kept it somewhere else. He had to sell it. And he will lift it only because he has to do business. If the business is closed, then where will he take it? And why should he lift it? And your Kanun doesn't make any difference whether he lifts it or not, whether he is liable for the delay or not. What kind of an astute understanding of the entire judgment we take so much of time and pains to.
I think we have heard it for 8 to 10 days before, and full opportunity to you, repeated affidavits.
We do not know if the businessman still survives or he has already become bankrupt because the closure of the business for more than.
What they did, they have cancelled my license. Initially, they have suspended. So now they have cancelled, and thereafter they have kept everything sealed in that shop. I have to pay. The shop owner, landlord is asking for money for the rent of that fee. I'm not in a position to pay that rent. And this they have done against the provisions of the excise act, wherein there is provision to seal, make an inventory, take the possession of entire excise.
This we are in contempt jurisdiction, and they have made a mockery of our order.
No, you see, Mr. Prabhat, because of the fact that you have paid that fine of ₹1 lakh, so there is an admission of guilt on your part. The only reason is the delay in taking the decision. And the delay part they are leaving, the penalty for the delay part they are leaving, that Vilam should. But the main amount for that delay part you are still living from. And there is an opinion of the learned AG which says, सौम्य दृष्टि रखा जाए. तब तो क्या सौम्य दृष्टि यही रखें? हिंदी में ओपिनियन था कि इंग्लिश में था? इंग्लिश में lenient word must have been used. So, we are really concerned because we do not know.
No, damages का सूत्र थोड़ी.
वो अलग चीज है. We are concerned that. We are concerned, Mr. Prabhat, sympathy with your client because he may not be able to do any business now. He may not be in a position.
Capital punishment दे दिया for your laches.
And sister rightly pointed out, therefore, for delay in the deposit of E, D, and E, where the penalty cannot be made liable alone. You see, there are two ways of deciding things. Straight away, we take over the role of the deputy commissioner and act as if we are the original authority. But the principles of judicial review require that in a certiorari proceeding, you quash the proceeding and let them decide because they are the competent authority to apply the mind to the facts and the applicable provisions. Now you read the whole exercise and judgment in a way which the court perhaps never indicated or intended to. come out with the. In a contempt proceedings, court is the best judge of its own order. There is no dispute about that. We have expressed how we have understood our order and your order also. Now, if the contemners are really law-abiding officers and diligent, they should make amends. And we have given enough long rope. I mean, you may not realize because you are on the other side, but it gives us pangs of anxiety. Our conscience bites at the end of the day. ये आदमी तो फिर तो कोई काम के लायक ही नहीं रह गया ही फिर 1 साल तो हमारे यहाँ इनका केस पेंडिंग रहा रिट पिटिशन हो या कंटेम्प्ट मिला जुला करके और फिर आपने इतना दे दिया कि ये देने की परिस्थिति में नहीं रहे तो फिर ये एडजुडिकेशन का मतलब क्या है फिर तो कोर्ट के प्रोसीडिंग्स पे कोई ये नहीं ना रह जाएगा
And there was a clear order that you have to decide in accordance with law. So you have to show under what provision of law he can be made liable for even for payment of excise duty etc. on account of your lapses. And ये जो आपने compensation और इसकी बात की है ना, इसके अंदर कैसे आते हैं ये? It is neither a compensation nor a refund. He is not seeking refund. You just tell me. You refer to this clause. Yes, there 42(4). Yes. Is it a compensation? Is it a refund?
We will keep it on next Monday. Now we will not give longer dates because
There will be a liberty to amend this. Will we have this liberty to amend and file?
of course, you are in contempt. Na? So long you do not purge yourself, the contempt continues. That's the whole difficulty these days. The councils also not understand the purview of the contempt. So long the court's order is not, you can rectify it, of course, with permission of the court. We want to purge ourselves. And on the next day, please give us short, before the next date on this Friday, a short compilation of the relevant rules which you quote so that we can easily refer to before the proceedings, we can go through it earlier.
Because on the next date, if the order, if what we perceive as on today is not done, then we have to do something about it. No, it's a contempt proceeding. We'll do it. We'll do the needful. Tuesday is the last working day.
Last working day, you
For Holi.
enjoy Holi. Your association will throw.
Your association will come and say that no adverse order today. We will not be attending the court.
As a first case, you must have done.
Huh?
As a first case, you must have
Contempt में बहुत
It's
ज़्यादा.
a special bench. Na? So on today's proceedings, one main thing which sister already pointed out, the second Vilam Shulka Bakaya ka which period, why, after 29th of January or before 15th of October, nothing is clear. I was wondering that it might be, say, from 29th January onwards till date because he could not pay it because of writ proceedings and your delay in order. So now, whenever you pay, this is up-to-date calculation of that penalty. This is not the way in which you levy a penalty upon a person. Penalties are always levied with an opportunity to show cause. A supplementary show cause has been filed by the opposite party on, when has it been filed? Pursuant to the previous order dated so and so, enclosing a reasoned order. Bearing memo number 308 dated 3rd March 2022. The reasoned order doesn't appear to be in strict compliance of the order under offense, and the computation chart is also vague. at internal page 4 is vague. Stop. Then counsel for the state, Mr. Piyush Chitre's prays for time. To file supplementary show cause and for bringing on record any amendment to the reasoned order listed on 14th March 2020. Very good.